Hello and welcome to the Probate Do's and Don'ts seminar. Tonight we're going to be talking about a bunch of do's and don'ts for probate administrators and executors of the estate. I'm attorney Edward Littlejohn, the founding attorney and CEO here at Littlejohn Law, and our firm focuses on probate and real estate matters. We handle these matters throughout the entire state of Ohio. Tonight we have a special guest, our probate paralegal, Natalie Kuchera, who's going to be helping me with the seminar. Natalie, go ahead and say hello.
Hi, welcome in. If you have any questions, feel free to just drop them in the chat and we'll be sure to address your question whenever they pop up.
All right, great, Nat. Well, we're going to play this short video real quick here, Nat, and get this started. All right. All right, all right. So that's just a little bit about myself. I've been a probate and estate planning attorney since I started practicing. One of the things that I really enjoy about probate and estate planning matters is it's always an opportunity to help people make a well-informed decision and then also allow them assistance to transition their loved one's assets through a difficult time. So it's our goal tonight to make this presentation very helpful. And again, if you have any questions, feel free to put them into the chat. So, Natalie, the first thing I guess I want to talk about with you is kind of the difference between an administrator and an executor. You want to touch on the difference between administrator and executor for us?
Sure. So an executor is one who is nominated or designated to serve in the will, either that usually it's a choice by the testator who's drafting their will. Whereas an administrator, there is no will, so it's usually a close family member or a friend who would apply to the court to administer the estate.
Okay, great. So when we're talking about the administrators, Natalie, that can be anyone, right? There's just a family member or a close friend could be the administrator. So literally anyone could be the administrator. Is that correct?
Yeah, so there is a hierarchy of who can serve. Typically, if there's a surviving spouse, they are first, and then it goes to parents, children, close siblings. If there's a surviving spouse or someone who is entitled to administer ahead of you and they do not want to serve as administrator, you can file a waiver of right to administer in favor of another applicant. There in Ohio, there is a requirement that you are an Ohio resident. So you are not eligible if you are not an in-state resident of Ohio.
Okay, great. Well, that's very helpful, Natalie. So there's kind of an order of priority as to who can represent someone as an administrator when it comes to a deceased passing without a will. But if there's a will, we're going to look at the will for guidance as to who can be the executor and the administrator. Now, the important thing to remember is that an executor or an administrator is what we call a fiduciary. Now, a fiduciary is somebody who has specific responsibilities to maintain. Natalie, can you speak a little bit about the fiduciary responsibilities?
Sure. So there is a form that you will sign when you are applying to the court to be a fiduciary. There's, which we'll go over. We'll have an example of the form so you can kind of see what all you're agreeing to. Essentially, your main purpose is to administer the state faithfully, get all the assets, determine where they need to go, make sure they get where they need to go and be distributed to proper parties. But we will go through, there's, I think, maybe 12 responsibilities that you have Some counties have additional ones, but basically all the duties are the same.
Okay. Yeah, let's take a look at the fiduciary responsibilities now. So here in Ohio, here in Jefferson County, this is an example of the fiduciary's acceptance form. Now, as Natalie said, this applies to both administrators and executors of an estate. And as you'll see here at the bottom, the person who wants to be the administrator or executor, they would sign this document and it will be submitted to the probate court. Now, one of the first things it states is that you're going to give notice of the admission of the will to probate to all heirs and beneficiaries within 2 weeks and file a certificate of notice of the probate of will within 2 months. Natalie, is there anything you want to add to that? Because I think that's pretty self-explanatory, but you want to add any context or any examples that you've seen?
Sure. So a lot of the times what I find with a lot of clients, especially when there is a will, they think that they only need to notify who is in the will. But under Ohio law, you will notify anyone who would have been entitled to inherit had the decedent died without a will. So if there's a child that the will specifically disinherits, under Ohio law, you will need to notify them that an estate has been opened and that we're also probating the will. And that will kind of give them notice that an estate's being opened, just so they're in the loop. But that's often an issue that comes up, especially when there's disagreements between family. They don't want other family members involved, but that's something that is required under the Ohio laws.
Okay. And then in addition, Natalie, whenever we notify them of the will, we have to submit the original will to probate. Is that correct?
Yes.
So not a copy, but it has to be original with wet signatures, right?
Yes.
Okay, great. The other thing, Natalie, I guess it would be great to touch on is Form 1.0. Now, Form 1.0 is titled Surviving Spouse, Children, Next of Kin, Legatees, and Devisees. And this is kind of the form that you were talking about, that we have to notify all heirs, whether the will speaks directly to them or not. Is that correct?
Yes. So you will start with the surviving spouse. If there is no surviving spouse, you will go directly to children. You will list all the children. If there are no children, then you'll go up to parents. If there's no parents, siblings, that sort of thing. And on page 2, which we'll get to in a second, is where you would list anyone who is mentioned in the will to receive a specific distribution.
Okay. All right. That makes sense, Natalie. And so once we decide somebody's going to be the administrator, they would sign this fiduciary acceptance form. And then in addition, they would complete this form here, Form 4.0, application for authority to administer the estate. What is this form actually saying, Natalie?
Sure. So the top portion of the form is specifically information on the decedent. You'll list the date that they passed away, the address that they were currently residing when they did pass away, and then there's a specific section that says to ask what you're going to be appointed. So as we previously discussed, that's either executor or administrator, and then you'll move on to an estimated value of the estate. So you don't need to know exactly what all the assets are up front. This is just essentially your best guess. So if you know there's a bank account, but you don't know how much is in it, it's okay to put unknown, as long as when by the time we get to the estate inventory, which we'll talk about later, you have exact values. So you don't need exact values. It's okay if you don't know what all the assets are. You're just essentially notifying the court of your best guess. And then at the bottom, there's a few check boxes that you can check. Most of them have to do with bond, if bond is required, which is something we'll touch on later on. And then you'll sign the form at the bottom. And if you're represented by an attorney, they will also sign this form.
Okay, and then I see down here at the bottom, it talks about a waiver of right to administer. What is this talking about here, Nat?
Sure. So if someone is nominated in the will first and they do not want to serve as executor, or they just choose they don't want to, they can sign this form here saying that I know I have the priority, but I'm choosing not to do it in favor of another applicant. And then they would just sign this form so the court knows that you were notified that we're in this estate and you're voluntarily choosing not to administer it.
Okay, and then if someone passes away without a will, and there's like 2 children or 3 children, would they also sign this waiver of right to administer?
Yes, so even if they're not qualified to serve, say they live in Wisconsin, most county courts will still require them to sign a waiver in favor of someone else administering the estate.
Okay, great. If there are any questions, feel free to put them in the chat as we continue to progress throughout this seminar. All right, Natalie. Well, that was very helpful. The next thing, Natalie, we want to talk about is kind of bond. Now, bond is an insurance policy that the administrator or the executor may have to get in order to safeguard against the loss or the concealment of assets. Because remember, an administrator and executor is a fiduciary. And as a fiduciary, their responsibility is to collect and safeguard all of the assets that are within the probate court's purview, which will be all of those estate assets. Right, Nat? Okay. You said there's a special form, and we can take a look at that form that we'd have to fill out for bond. Oh, we're back to the fiduciary acceptance. Well, let's
Holy.
come back to the bond, Natalie, and keep going down this fiduciary acceptance. So the fiduciary acceptance, we have to file an inventory of the real and personal property, deposit funds into a bank. We call that an estate account. The part that I was just talking about is keep the estate funds separate in separate accounts at all times during the administration, invest all funds in a lawful manner, make and file all final and distributive accounts within 6 months after the appointment, file tax returns, obtain court approval prior to any personal purchases or other dealings, and obtain court approval for the payment of attorney's fees before the final account is prepared unless paid with the written consent of all beneficiaries in a solvent estate. So those are kind of all the duties and responsibilities that the administrator or executor would accept when it comes to their duties. Right, Nat?
Yeah.
Okay. Once this is submitted to the probate court, along with the prior form 4.0, we receive the letter of authority, which is this form here. Is that correct?
Yes.
Now, can you tell us about the letter of authority? I always say a letter of authority is our magic key to kind of open up any lock. But can you speak a little bit more about the letter of authority?
Sure. So this document will be issued by the probate court, and anytime once you're appointed that you need to show your authority to act on behalf of the estate, whether you're taking this to a bank to see what amount is in the bank, if there was an IRA, if there's any pensions that the decedent was entitled to, they're probably not going to speak to you unless you have this document. So this document will be, there's a certified stamp that the court puts on it, the judge signs off on it, and like Attorney Littlejohn said, this is your golden ticket to administering the rest of the estate. This is how you'll get all the info to put on the estate inventory. And if there's any question on whether the decedent had, bank accounts, the IRAs, this is what they'll need along with the death certificate in order to get any information.
Okay. And Natalie, something that we see quite frequently are people get named as an administrator in a will. I mean, excuse me, as an executor in a will, but they don't have this letter of authority. So technically, even though the will says they can act, because they don't have this specific letter of authority from the probate court, they don't have legal authority to act on behalf of the estate.
Yeah, that's correct. And a lot of times clients want to get the estate process started as quickly as possible. So even before an estate is open, they're trying to gather assets and determine, what assets there are if there was a will. So it's important to realize that until the court issues this, you do not have authority to act on behalf of the estate.
Okay. The next thing I want to transition, Natalie, into kind of our do's and don'ts of probate administration. The do's and don'ts are kind of a list of things that Natalie and I have seen over the years when it comes to administering estates. You know, there would be things that I guess you would think are common sense, and it's kind of common sense to us because we do this all the time. But for people who are first time administrators or first time executors, often they're unsure what they can and can't do. Okay. And what we try to advise them is that if they just remember the fiduciary acceptance form, it's a great guide, right? To say, you know, you're going to safeguard the property, you're going to keep your assets separate from the estate assets. It's kind of a great start to the do's and don'ts. Natalie, you want to go ahead and jump into some of the do's and don'ts for us?
Sure. So the first do is to read the will thoroughly. So if the decedent created a will, they have a guideline on how they want their assets distributed, who they want appointed as executor, where they want their assets to go, and if they want to make specific requests, that's something that we'll need to follow and you'll need to follow as executor of the estate. So it's very important that if there is a will, we look at that. That's what the court's going to look at when we go to distribute the assets. So if there's a specific bequest in the will and here the executor gives it to another person, the court's obviously going to notice that, and then there could potentially be an issue. But if there's a will, we need to follow it very carefully and make sure that everything is done in accordance with how the decedent wanted it to be.
Okay, that's great, Natalie. Another one we have is make sure you file the will with the probate court, right? And we want to file that will as soon as possible. Far too often we see cases where people are fighting over which version of the will is the valid will, right? Natalie and I are currently working on a case where a client updated their will 3 years in a row. Okay, and so now their will's updated 3 years in a row, and the family is fighting over which will is actually the valid and an updated will. This is why it's important to make sure that you file the original will with the probate court. Natalie, you want to talk about the next one where you should notify all interested parties?
Yes, so all interested parties, any beneficiaries or any parties involved in the estate, that kind of touches on something we briefly addressed previously, where if there is a will that disinherits a child or does not mention a child that they had, they would still need to be notified under Ohio law. So that's specifically what this one is, just to make sure that they know that there's a will, that it's being probated, and that an estate is being opened with the probate court.
Okay. Let's talk about opening an estate account. And I want to use this as a segue to hit one of the questions that are in the chat. And one of the questions in the chat say, do the letters of authority last the entire time that the estate is opened? Natalie, I'll let you take that, and then I'll take the one about opening an estate account. Okay.
Sure. So yes, once the letters of authority are issued, they are valid until the court issues an entry closing the estate. So typically that's after a final account has been filed and approved. You'll receive an entry issued by the judge that specifically says the fiduciary is discharged and the case is closed. So yes, they do last for the entire time the estate's open.
And once you receive that court order to say that you're discharged, you can no longer act on behalf of the estate, right, Natalie?
Yes, your letters of authority will expire once the court closes the case and discharges the fiduciary.
Right. And what we've seen over the years are, you know, sometimes when somebody becomes an executor or an administrator, they don't know all of the assets of the deceased. And so they do their best guess at identifying and collecting all the assets of the deceased. And we've had cases where we've closed the estate and 6 months later, they find what we call a newly discovered asset. And in that situation, we have to go back to the probate court and ask for authority to issue new executor letters or letters of authority so that they can deal with this new asset. So Natalie, when we're talking about an estate account, one of the things that we're talking about is taking money that was in a regular account, closing that account, and then putting it into a special bank account that we call an estate account. Now, Natalie, one of the things that I know you've seen, and I've seen it too, but you see it more on a daily basis, is the importance of maintaining good records of the estate account. All right. Can you tell us why it's important to maintain good records in the estate account?
Sure. So one of the things that you'll need to do as fiduciary is file an estate accounting at the very end to ensure that all the assets that you've gathered, that you've safeguarded throughout the whole process have been distributed. And what you would need to submit to the probate court is receipts or canceled checks, bank statements showing that any money that went out of the estate account and what it was for. So there's certain expenses that are appropriate for an estate account for funds to be out of the estate account, such as anything that benefits the estate, such as paying property taxes or paying utilities, paying the mortgage, things like that. The court will go through the final accounting, see every deduction, make sure it was legitimate expense, and they'll account for every penny that came out just to ensure that all the money is accounted for and all the money went where it is supposed to.
And just to kind of give you guys a little insight, here's what a sample fiduciary's account would look like. This fiduciary account, it lists all of the assets, and you file that. There's partial accountings, then there's the final account. But the court, like she said, they're going to want to see what was the personal property not sold, what were the proceeds from any sales, real estate not sold, proceeds from any sale of the real estate, any income, other receipts, other distribution, were there fiduciary fees, attorney's fees, other administration fees, debts and claims against the estate. And we're going to touch on that in a few minutes about legal debts that are claims against the estate that must be paid versus other debts that are not legal claims against the estate. Distribution of property. When we complete this, the goal is to get the balance down to zero. We've had situations where it doesn't add up because people were spending money for what we call improper means. Natalie, you want to talk about some of those things that people were spending money that they shouldn't be spending the money on?
Sure. So we've seen several instances over the years of withdrawals that were made from the estate account for personal usage. We had some where a executor used estate funds to pay for their personal copay at their family doctor. Funds that were just withdrawn for casino purchases. They went to the casino, taken pets to the vet. We've had a few where they withdrew money to spend it on Christmas gifts. It was around the holidays. So things like that aren't estate expenses that were being taken out for the personal gain of the executor of the estate.
And again, the key is if you have bills as an executor, you need to separate your bills from the bills of the estate. And like Natalie said, I mean, it was a no-brainer to us that you can't take estate funds and go to a casino. But the person who was the administrator, they did that. It's a no-brainer to us that you cannot take estate funds to take your cat to the vet, right? Or to pay your own copay because you're the administrator, right? And so it creates a friction point when we're filling out that accounting and we're trying to classify all of these expenses that aren't estate expenses. I remember one case that we worked on where it was and Natalie, correct me if I'm wrong, but I think it was a father and daughter who shared a bank account, and it was a Discover card. And, the dad, he had his own bill, but because it was a joint account, the daughter also had her bill. And so there were some expenses that got mixed in with the two. Now, it's not proper for the estate to pay all of her bills, but it is proper for the estate to pay his Discover card, credit card bills. So I guess, Natalie, that's a great segue into talking about some of the legal debts that we are obligated to pay. And specifically, I guess we can start with creditors making a claim. Do you want to talk about how creditors make a claim here in Ohio?
Sure. So under Ohio law, any creditors have 6 months from the decedent's date of death to file a claim against an estate. And to file a claim against the estate, this is done in writing either to the attorney for the estate, the administrator, or the executor of the estate. They can also file a written claim to the probate court. And the only way typically to do that is if there's an estate open. So if an estate is not open, a creditor can they can open the estate on their own and they'll be appointed specifically for the purposes of asserting a claim. And that's how most family members are then notified. So if there is no claim made, say you had unpaid medical bills and the estate was not open for 6 months, then those payments just don't have to be made. And a lot of clients feel like they need to make these payments. They feel like the hospital or the credit card company deserve to be paid for services rendered. And essentially that's not the case. If there's not a written claim, you do not need to pay any of the debts.
Right. And the only caveat to that, Natalie, I would like to add is if the debt is secured debt. So if there's a mortgage on the home or there's a loan or a lien on a car, you have to pay that debt whether it's the deceased debt or not. Because if you don't, then they have the right to foreclose or on a home or repossess a car. So as long as the creditor makes a proper claim against an estate, that claim will have to be paid. One of the most common claims that we see on a daily basis are Medicaid claims. And the Medicaid claims come as a result of someone being on Medicaid or receiving some sort of government benefits, and that Medicaid wants to be reimbursed for the benefits that were paid out. And as a result of that, Medicaid has priority to be reimbursed from the estate. And under Ohio law, now you want to speak to the fact that they have 1 year from the notice, Medicaid?
Yeah, so Medicaid has that 1 year where they could essentially file the claim. Is that correct?
Yep, yeah. And so what we see is what the duty as the administrator, and when you work with our office, is we notify Medicaid of the deceased death. And once we notify them of the death, then Medicaid has a year to make a claim to say, hey, we want reimbursed. And if they fail to make the claim within the year, they actually lose their right for reimbursement. All right, any questions? Oh, looks like we have another one there. Is there a certain amount of time that a claim can be made? Yes. Creditors have 6 months to make a claim against an estate. So if a creditor fails to make a claim within the 6 months, even if you as the administrator want to pay it, legally you are not obligated to pay it. And the probate court may reject the fact that you wanted to pay it or tried to pay it with the estate funds. So Natalie, kind of bringing this thing full circle, we have got somebody appointed as the administrator, gone over the do's and don'ts of what they should do and what they shouldn't do. There's going to be a point where they've collected all the assets and they need to file an inventory. You want to talk a little bit about the inventory and the appraisal as the administrator or executor?
Sure. So once you get your letter of authority appointing you as executor administrator, then you can go to a bank. If you knew they had a West Banco checking account, but the bank wouldn't talk to you before, now that you have this letter of authority, they can talk to you and let you know how much exactly was in that bank account at the time of decedent passed. And that's the value that you'll end up putting on the inventory. So the difference between the 4.0, which was the application, where we just had an estimate of the value, the inventory requires actual value. So for houses, real estate will typically use the auditor's value. If the family decides to sell it, sometimes they'll want an appraiser. So you can apply to the court to get an appraiser appointed who can then go out and give an up-to-date value on any real estate. If there's items that don't have a readily ascertainable value, such as a card collection, or we had he had a lot of trailers. So we had an auctioneer go out and appraise the assets, and then that's the amount that we would put on the inventory. So for vehicles, we can use Kelley Blue Book as long as the car is not older than 1992. If you have an older vehicle, then we'll likely need to find an appraiser who can go out and get an actual value for that car as well. And then we'll put it on the 6.0, which is the inventory and appraisal. There's a schedule of assets that will list the assets along with the either appraised or the exact amount for like bank accounts and things like that, which I know will show you an example of what an inventory looks like as well.
Yeah, let me get that up for you, Nat. Here's the inventory. So like Natalie was saying, at the beginning, we were guessing when we filled out form 4.0, we were unsure. Now that we have the letter of authority, we can go into the bank account and get actual values. And so we would identify, intangible personal property. We can get actual values for real estate. And then we would complete this form here. And then again, there are waivers for the next of kin to waive their right to notice of a hearing on the inventory. And then this is what it would look like if there were schedule of assets. First National Bank, $1,000, real estate, $200,000, and it would just carry on for all of the assets of the estate. Now, again, the heirs have a right to receive notice of a hearing on the inventory, or they can waive their right to receive notice. Now, often we'll see family members object to the inventory because they feel like maybe there were some assets that should have been included in the estate that are not there. They're not listed on that schedule of assets. Or we've seen people say assets were missing. So the administrator, it's your duty to make sure that we have all of the assets. So if you're aware of assets that are missing, you can file what we call a concealment action to get those assets back into the estate if there are estate assets that are missing. Anything you want to touch base on with that, Natalie?
No, I think that pretty much covers the inventory.
Okay. And so now we're at the final point where the inventory's been approved. Once the inventory is approved, we have 60 days for the final accounting to be filed. And so we have to complete that form where we say, here are all the assets, here are all the expenses that we plan on paying, here are all the bank statements, here are all the receipts, and all of that gets submitted to the probate court. Along with that, you'll see what we call the administrator's fee, which is the executor's fee or the fiduciary fee. And here in Ohio, we have a fee schedule that the administrators or executors are entitled to. Now, some of them waive their right to receive it. Some of them request it as an understatement. They demand it, right? And they say, I'm not going to do it unless I get my fee. The fee schedule here in Ohio is as follows. For the first 100,000, the administrator is entitled to 4%. So if it's $100,000 in the estate, they will be entitled to the first 4%. Anything above $100,000, but not exceeding $400,000, they're entitled to 3% of the next. And then anything above $400,000, they're entitled to 2%. Now, there's an attorney fee schedule that's based very similar, but sometimes the percentages are different. And each county has the right to modify this fee schedule. And the probate court has the ultimate discretion to approve or deny any fees that are presented to them for payment. Natalie, do you want to talk a little bit about the exorbitant fee where the administrator can get fee in excess of this guideline? When they had to perform a lot of work.
Yeah, so some courts will, if there was an extraordinary amount of work, it exceeds kind of what a normal estate would be. Say the decedent had a company that we had to wind down. If they had a lot of properties that need to be sold, the court can adjust this accordingly. They'll look at the total value of the estate, they'll look at all the work that was put in, they'll look at everything you've done as administrator, and they have the discretion to allot you an amount that's greater than what's allowed by the statute.
Okay, great. Any other questions out there? No? Natalie, anything else that you want to tell the viewers about the do's and don'ts for probate administrators?
Yeah, so a lot of the times I encounter clients who initially retain us and they're extremely worried about doing something wrong. And that's why it's so important to have an attorney kind of guide you through this process because it is a lengthy process. There's a lot that you need to do, and we're here to help guide you. So if you have any questions based on any material we covered today or any other questions, please feel free to ask. We know this is very daunting. There's a lot of information, and we're here to provide you with as much knowledge as we can.
Oh, thank you. Thank you for that, Natalie. And like Natalie said, it's a very lengthy process. I mean, we pride ourselves on getting the estates closed between 9 and 12 months, but we've seen estates that are opened up for 2 years, 3 years. I know Natalie's helping me out with an estate that's been opened up since 2021. You know what I mean? So we're going on 4 years and we're still trying to get it wrapped up because there are a lot of moving parts. And then the other thing to keep in mind are these internal deadlines that the probate court establishes. Once an estate's opened up, they have 90 days to appoint somebody as the administrator. Normally, they do it a lot quicker than 90 days, but they have 90 days. And then from there's 60 days you have to file your inventory. And then there's another 60 days once the inventory is approved to file the final accounting. So it can go very fast, but most of the times, people don't know what assets their loved ones have. So they're spending a lot of time using that letter of authority to track down assets to make sure the estate has been administered properly. If you guys have any additional questions, feel free to reach out to us, 740-346-2899. And remember, where there's a will, there's a way. Where there's no will, then there's probate. But the best plan is a trust plan. And guess what? I'm your trust man. See you guys soon. Bye.